Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. He is the Managing Director of IPCom. I'm very happy to have here today Pio Suh. Welcome.
Thank you very much, Tim, for the invitation. I'm happy to be here.
Glad having you, Pio. And it would be great to get started and learn a little bit more about yourself. You came a long way. You've been with IPCom now 3.5 years, almost 4 years, but you've been in other positions before that. And you also dealt with standard essential patents a lot. So let us know a little bit about your background here.
Sure. So short introduction to myself, to my person. I'm Korean origin. My parents came to Germany in the 60s, 70s. So I was born here, went to school, went to university in Cologne. And after my passing my bar exam, I quickly got into the SEP licensing business via Philips. Philips has its headquarters in Eindhoven, but also research labs in Germany, in Aachen, not far from Cologne. And I started there in the IP department, Philips IPNS. IPNS stands for Intellectual Property and Standards. And I was in a worldwide team consisting of 80 people, and was a great experience. And jumping into this international business of IP licensing. And at that time, Philips was licensing optical storage, right? So starting with CD patents regarding the CD technology, DVD, later on Blu-ray. And those were also standard essential patents, right? And imagine the world before streaming, video on demand. That was DVD, all about DVD, right? We had this blockbuster shops of DVD, and everything, the movie industry was relying and depending on DVD. And so DVD was really big. DVD players, CD-ROM, DVD-ROM drives for PCs at that time, right? TV devices, LCD TV devices with DVD players integrated. The DVD content manufacturers with the replicators. So it was a huge program, and I was part of it. And that was the first time I was getting in touch with patent licensing and also SEP standard essential patent licensing.
Yeah, very, very interesting. And I see you've also been with OneRed, which is a patent pool that was administered by Philips, right?
Yeah, so OneRed basically is a spin out of the licensing team, right? So because Philips at that time decided to spin it out to have a more kind of independent administrator, licensing administrator, and that's why the decision was to create a new entity, and that was basically the same team was shifted to the new entity.
Yeah,
doing very much the same.
Okay, very interesting. Yeah. And you came a long way after that, also been with Oracle, Qualcomm to then join IPCom. How did you get into the telecom world then?
Basically, starting with Qualcomm. I always was on the license source side, right? Philips, Oracle, Qualcomm, and Qualcomm was really, I mean, everybody knows Qualcomm, very strong in the ITC world, in the wireless telecommunication, and I was working there for the licensing program for QTL, Qualcomm Technology Licensing, right? That was the licensing department, so to say, or licensing business unit of Qualcomm. And I was working there, and and then IPCom crossed my way, and IPCom being in the very similar or very same field of telecommunication and wireless connectivity, And that's why I decided also to move over, because the shift was not that big. It was also on the licensor patent owner side. So I was basically continuing what I have done with Qualcomm and the previous stations.
And IPCom is a player in the German market. I remember well also because I got in touch with IPCom also 15 years ago when some politicians in Germany were scared. There's this company and we don't know what they do. But maybe can you explain a bit what's the business model of IPCom? How do they work with patents, licensed patents in comparison maybe to other companies? What's the particularity of that business model?
So IPCom was founded 15 years in 2007 by Bernhard Frohwitter and Christoph Scheller, and they have purchased the so-called Bosch portfolio regarding smartphone and handsets, starting with I think 2G, 3G, 4G telecommunication generations. And then this was also backed up by a later purchase of the Hitachi portfolio. And Bernhard Frohwitter and Christoph Schoeller at the time was doing the licensing business by monetizing those two portfolios. In 2014, IPCom expanded, and this is not very well known in the industry. IPCom expanded its business by hiring inventors, a team of high-profile inventors from Bosch, from Siemens, and one of the leading inventors here in IPCom was also the leading inventor of the so-called famous 108 patent from Bosch. So basically, he did caused all the mess later on. I'm just kidding. And so, yeah, they're actively in the standardization groups and 3GPP and actively contributing and doing some inventions. And that's why we are also growing our own 5G portfolio.
So to get it right, you are also now filing patents as IPCom. You are in prosecution and
Correct.
and standards development.
Correct. And we also decided, and this is a recent development, and the good that you pointed to that, is not only we have an inventors team, but also we have our patent prosecution department in-house, right? Patent attorneys who are acting with the inventors team, getting the ideas, putting that into paper, into a claim language, checking the claims itself, tweaking it, because we want to have a very high qualified portfolio, right? Not just any patents, but a high qualified patent portfolio that is eligible, for monetizing and for future litigation if that is necessary.
Well understood. Maybe again on the business model, because I know the perception of businesses like IPCom, I think, has changed in the past years. I remember back in the days, people were calling you patent trolls, patent sharks. But I think these days are in a way over. People appreciate and understand that business model much better now. But can you explain a little bit of what was IPCom doing maybe 15 years ago when they got the Bosch patents? How does it work? You have also some financial people in the background from Fortress. Can you elaborate a little bit on this?
Sure. I mean, 15 years ago, the licensing landscape was totally different, really totally different from now, and even earlier. I mean, I started at Philips in 2007, right? And at that time, we didn't have all the discussion about antitrust, patent law, friend licensing, friend obligations, and patent trolls, patent dodgers. I'm calling all the companies as a contrast to patent trolls, who are not willing to take a license and become legal by doing that, patent dodgers, right? That's that's the term that I want to promote in this sense. But it was totally different. So it was a kind of a basic starting point to acknowledge that patent law is property law, right? And it's an absolute law. And you as a patent owner, of course, have the right at your own discretion who to grant the patent. And if you grant the patent, also to ask for a fair reward, right? And that's why it was possible with this sentiment to enforce your patent rights in a very broad way, especially in Germany. You know, I'm talking about border seizures, border detentions measures, preliminary injunctions, injunction itself, prohibiting basically operating companies to sell their products in the market. And that was a real thing at the time, right? And also, as property law is an absolute law and qualified as a criminal act, because that makes sense, right? If you violate any property from a third party or another person, if you damage a car, then that's also a criminal act, right? And if you are using anyone's patents unauthorized and without paying, that's also a criminal act in most of the in many of the countries, right? And that's why also the so-called exhibition seizures was also a great tool to enforce your rights. And I have done many seizure programs on the IFA. You know IFA, right? In Berlin, in the International Funkausstellung, the big exhibition, and SEBIT in Hanover. And we were doing also the what is it? The preliminary injunctions, and also sometimes criminal complaints against DVD manufacturers. And the German government and German police was taking that very serious. And I have a photo that I have made at the time, so I have the copyrights on that, and I want to show you that what that really means. Can you see that?
Yeah.
So you see 3 police officers, right, upon a criminal complaint for possible patent infringement, protecting a booth. And there was not just one booth, it was many, many booths, right?
Yeah.
You know, fully armed, said, do not disturb any investigations. And you see the gentleman is sitting there doing some investigations about the patent status.
Right.
So that was really, I mean, that was enforcement in its very definition. And that was also the tools why Philips at the time was so successful in patent licensing. Sometimes if somebody is not willing to pay you, you need to, you know, leverage your position in using these kind of tools and measures. And that was really a tool that was efficient and was bringing the parties to the table. And then over the years, and you were asking what was the situation there, right? And what's the situation today? And it is totally upside down, because big tech companies who were implementers using these patents, standard essential patents in the consumer electronics, in audio, video technology, smartphone technology, were recognizing that is something we cannot fight against with, right? If you have a criminal complaint, if you have a seizure, you know, we had 1,000 DVDs in containers at the port of Rotterdam, Bremen, Hamburg, Gdansk in Poland, right? Then you cannot do any sales, and it's a great leverage on the implementers. And they said, okay, we need to do something against it, and that's why lobbying started, right? With millions of investment. And it started, I think, the first signal you could see was basically, I would say, the Orange Book standard decision in 2009. Right, that was maybe many people do not know that it was done within our team. It was a patent infringement case from Philips against SK Kassetten, SK-Kassetten was a DVD, CD, DVD replicator
Okay.
in the eastern part of Germany. And so that was the basic case, and then it escalated, and then was resulted in the Orange Book decision. Orange Book means the Orange Book is the technical specification book for the DVD format, and that's why they call it Orange Book decision, right? And later on we had Huawei, ZTE, UP, and the famous Unwired Planet case in the UK by Judge Burrs, and so, and all the European Commission initiatives you can see. And today, I mean, it's I would say, and somebody correct me from the audience, it's de facto impossible to reach a border seizure, to get a preliminary injunction, either on a normal way or specifically for exhibitions. And even getting an injunction on the normal way from a German court or different other courts in different jurisdiction, it's really a uphill battle. It's difficult, and actually it should be generally, if you go to the basics, it should be the other way around. If you're a patent owner, you should have the right, and you should make it more easy to get support on a legal basis how to handle your property.
Yeah, that makes sense. But we are talking about also a particular case here. We talk about standard essential patents, and I think injunctions for non-essentials is still a vehicle that can be used. You also with IPCom have a portfolio of essential patents and non-essential patents. How do you treat those differently, or is there a different strategy to one or the other? How do you approach that?
So generally, our licensing policy is based on global portfolio license, right? So because if you look at the smartphone industry, it's very global, it's very international. There is no local market, right? There is no, let's say, a Polish manufacturer who is only selling a manufacturing smartphone for the Polish market, right? We see that almost most of the smartphones are manufactured in China, and then from there delivered and sold to any country. So we have this international and global aspect. It doesn't make sense to give a license on a country by country basis. Right? Say you get a part license for Poland, not for Germany, but for the UK, doesn't make sense. So that's why we always go for a global license, and also for a portfolio license that covers SEPs as well as non-SEPs, because also there it doesn't make sense to give a license for a specific portion of patents, regardless whether it's SEPs or non-SEPs. It has a relevance maybe in some jurisdictions, such as in Germany, right, or in China, or in the US, where you only can get damages, for example, for the number of patents that you have sued, you have in litigation, and they survived validity, right? Instead of look at the very famous London or UK decision from Judge Burrs, where he's saying, okay, you are suing just 2 patents, but you are eligible to ask for a portfolio rate, for a rate that covers the whole portfolio, right? And so that's our licensing policy, and I think that is also in line with the reality, the business reality.
But I guess still difficult to manage, because even though licenses are globally, especially a FRAND license, because you move with your devices from country to country, it doesn't make sense that there might be a different or that you have injunctions in some countries you don't. But even though it's negotiated globally, and some courts even decide or want to decide it globally, in the end, a court is a local jurisdiction, right? And I know IPCom is actively enforcing worldwide. how do you manage that? And can you maybe elaborate also on the differences in these countries in terms of predictability of outcomes? Some, I guess, are more patent holder friendly than others. What is your experience there?
That's a very good question. So generally, you need to first distinguish who are the potential licensees, right? You have the industry of the smartphone manufacturers, the implementers, and that are very easy to identify. I mean, these are mostly big companies, right? Because the hurdle to enter into the smartphone industry or manufacturing smartphones is quite high. You need to have the plans, the manufacturing plans, the engineers, software, hardware, all that. It's not that easy instead of, buying a machine and printing or pressing a DVD, right? So the hurdles are very, very quite high. And that's why you see also the big companies, Huawei, Samsung, LG, Apple, HTC, Nokia at the time, and now the Chinese long tails, Oppo, Vivo, Xiaomi coming into the market, pressing into the market very successfully. So these are big companies with also some substantial, significant revenue, right? Having said that, they are also in the position to educate themselves and also to defend themselves, right? At the same time, if you look, you can also look into a different industry regarding the carriers, right? On the other side, you have the smartphone interacting with the network. So you also have the network carriers, and there it's a little bit different because you have the national network carriers in Germany, Deutsche Telekom, Vodafone, Telefonica, O2. In US, totally different, right? AT&T, Verizon, Sprint. So different sets of targets, and these are actually not, traditionally not acting internationally, right? We see AT&T has operations mainly in the US, right? So it's a different scope of the license, and also you have this kind of speciality that those guys, they try, of course, to get rid of any licensing demands coming from IPCom or from another company, and they're saying, hey, please go to the equipment manufacturers, baseband station manufacturers, right? Because we have indemnification and we do not want to deal with that.
Probably comparable but to the automotive industry discussions right now, where typically also the OEMs, the auto manufacturers are approached, not the tier ones, tier twos who have, who deliver smaller valued connectivity boxes, right?
Exactly. It's about which on the supply chain you should license, right? And it is the very same situation that you have with tier one, tier two suppliers to the automotive manufacturers.
Right.
Correct. Yeah.
So that makes you litigate and enforce internationally. Maybe to get some insights on your strategy here. SEP licensing is a challenge. I've heard that a lot, especially from SEP owners, always call out for the unwilling licensees. It takes forever. There's a lot of delays in there. How do you typically approach that? I mean, thinking about 4G, 5G patents, you could potentially approach thousands of companies at the same time, just sending out some love letters. Or are you more targeted and you go to the particular ones you know best and try to negotiate right away?
Right. So hold up. That's the big problem in reality. It's a big problem for licensing companies. And let me put myself in the shoes of a operating an implementer, for example, right? And I would think about a licensing demand coming from IPCom, coming from any licensing company. My position as an chief of IP or licensing manager in this company, in this organization, would be what's the KPI? What's the KPI of those guys? To save money and to minimize risks, right? These are the basic KPIs or the main KPIs for those guys. So they're coming now and they're thinking, okay, how should we address a licensing demand from IPCom? And I would decide in their position, oh, of course, the same way. They say, okay, let's try to delay. Let's try to delay, hold up, and get things, and maybe, and for different reasons, maybe it will go away, right? There are many licensing companies who deem to have great patents, and it turns out to be it's crap, right? And they try to still enforce it, and then they see, okay, oh, we need to litigate because they are not reacting. And litigation means in the UK and US, a investment of a couple million. Not any company can do that. So it's one of the factors to say, let's wait and see whether it goes away. If it's not going away, then still it's worth it to wait until infinity, because what does it mean? It's always cheaper to settle at the end before any escalation rather than taking a license from the beginning. It's always like that. It's a business, let's say, rule, right? So you try to delay, and then at some point in time, if you see that there's no way out, and in the current stage, it is unfortunately that we need to litigate. Litigation is a must in order to bring the parties to the table. In the previous times, not necessarily it was a precondition, because just the concern to get injuncted by preliminary injunction for that manager or chief of IP is reason enough to go to the, to negotiate, because if you get injuncted, you are in the spotlight. Yeah, you're in the spotlight within the organization, and you do not want risk minimization. You do not want to let that happen, right? So at that time, it was possible, to have this kind of meaningful negotiations without any legal measures. But nowadays, because they exactly know that this is not possible, there's no threat of injunction via preliminary injunction, border seizures, whatever. They say, okay, what do we have to lose, right? Let's wait. And then 2 years, 3 years pass by without any settlement. And then we'll say, okay, let's talk about it. But we want this discount, for the past use, for the so-called past use. We just, we pay you just a portion of it to get it done quickly, right? You want to settle, we want to settle. So give us a discount in order to bring that through the finishing line. That's the way they negotiate. And you as a patent owner, you do not want to, stand on your initial position, which would be the fair position. Of course, you will give in, right? Because you say, okay, you're also fearing litigation with a couple million of investment. Also, we're losing another time of 2, 3, 4, 5 years before a final decision will come down. And so from that perspective, holdout is a real tool to save money without any additional risk that they're facing, right? And of course, so from our perspective, it's a big problem, because we want to play fair, we want to play as transparent as possible. But we see some companies who are either ignoring us on purpose or entertaining some kind of discussion that are not meaningful, right? Just for the purpose of we reply, but there's no real discussion on the merits. And this is a big problem for us. And we do not see really, and I'm really arguing from not from the legal perspective or from the academic perspective, but from the real world perspective, because I'm sitting with these companies in a negotiating room, right, face to face. I'm talking to them, right, and I'm hearing them. They're hearing me, or hearing us, our negotiation team. And all the landmark decisions that are, you can find in Google or in the internet, in the public domain, they are trying to, the judges are trying to get the things straight in setting up some friend rules, right? What is friend? What is fair? What should both parties do in order to overcome the hold up problem, right? And these are fair rules. Smart people, of course, they will set the rules, but there is a disconnect. To be honest, sorry, there's a disconnect between those rules and the real world negotiations, right? And I can give you one example. So there's this so-called Huawei ZTE decision, the ping pong effect, right? The friend dance set up in a way that a licensor, such as IPCom, should make a written offer, a well-argued offer, to be most transparent, for a implementer to see, okay, what is the license scope, what is the demand, why is it that amount IPCom is asking for. Fine, we adhere to those conditions voluntarily, because we also want to show the reason of taking a license, right? And then the second rule of this friend regime is either to accept, and that's not the case, right? Nobody in my 15 16 years career said, okay, I accept your friend offer, that's fine, let's sign. It's not that. They always reject, of course. They always reject or remain silent. So what's then? Huawei ZTE says, make a counter offer. Okay, so I see many times they don't care about the counter offer, right? And if they come up with a counter offer, it's marginal. It's really marginal, right? And they don't dare to or make any efforts to back up this marginal amount, why they come up with this is such a small amount. They don't, because they can, right? That's my experience, my real life experience.
Right.
So we are not at the end. What is the third step? The Huawei ZTE friend regime is setting up. They say, okay, if the implementer is rejecting the offer, they should come up with a deposit, right? A deposit they should pay to an escrow account. Nice thought. And also the licensor could demand that, right? You should then make a deposit. But what's the amount of the deposit? Big problem. Nobody's answering that. No judge, no court, no decision, nobody, right? So we are I felt kind of left alone, because we had the situation. Okay, they rejected the offer. Say, okay, let's make it. Let's adhere to the friend rules of Huawei ZTE. Let's make a deposit. What's the amount? Is it the marginal amount? A 5,000 deposit? Anybody can do that, right? Doesn't make any change. We make a 5,000 deposit. That's about it, and make another hold up round for another 3 years. The patent expire in due course, without with expired patents, no injunction at all. And so that's one of the, let's say, examples where there is this kind of disconnect. It's a good intention, right? But the real world negotiation is totally different. And there are some attempts. Also, the very recent Siswahaya decision is saying, okay, you need to, they identified the hold up problem, and they say, okay, you need to respond as an implementer in a timely manner, in a serious way, having these kind of meaningful discussions. But the real world is totally different. The KPIs of the IP department and the managers, IP managers, are far more important, right? And as long as you don't get sanctionized and you don't have any threats, right, in that sense, what's the way you choose?
So put differently, without that injunction, you're only left with, litigation, right?
We are only left with litigation, and there I come back to the initial questions about the litigation strategy, the different jurisdictions, and there you will see also very fast and substantial changes and developments, right? So we as patent holders, major jurisdictions, you can say it's UK in Europe, Germany, primarily, and then followed by Netherlands and Netherlands and France, France with the saisie contrefaçon, with also the preliminary injunction in the evidential procedure. Some are, yeah. So these are the on a very high level. Some of the patent holders will also say this country is very important too as an enforcement country. When I was working for Philips, Russia was a real efficient enforcement country. Poland as well, Turkey, right? These are big markets. Turkey has population of I actually don't know. I need to Google it up. Let
More
me
than
go.
Germany, I guess, right?
Huh? Germany has 80 million, right? Population. I'll tell you in a sec. 84, same as Germany.
Oh yeah.
Big market.
Right.
Big market, right? So, okay. These are the major jurisdiction from our perspective. US is, of course, a major jurisdiction, and also China. China is coming now into the play more and more. And the problem with the Chinese jurisdiction, I would not say problem. I mean, the status in the previous years from the past traditionally is that the damages award are far lower than compared to the US, right? And but China is such a huge and important market because not only as a consumer market but also as a manufacturing country. As I said in the beginning, 100%, almost 100% of all smartphones are manufactured in China. So China as a patent-bearing country, right? If they are manufactured, also you are using the patent in the manufacturing process, not only by selling or reselling. It's also the manufacturing process. So if you can license and manufacture in China, basically you license the full amount, right? The full production. So I think that the Chinese government, I think that's not real news, right? Are now becoming more and more aware of their exceptional stance in the market, right? And the exceptional responsibility also when it comes to intellectual property protection, yes or no. And they're trying now to emphasize that. And sorry. They're trying now to emphasize that and try to accommodate. And we see now more and more efforts by the jurisdiction and legislation, but still there's still a gap, right? And we'll see quite soon, I guess, where in which direction that goes. It's very interesting to monitor because that's a very fast and fast development that's happening right now in China. In Germany, for example, as I said in the beginning, the injunction itself, to get an injunction, it's not that easy anymore. And there are so many obstacles to take. So it's not that, if you are a patent owner of a strong patent, survive validity, have a clear standard read, whatever, everything is fine, it doesn't mean that you automatically get an injunction. The narrative or the automatic injunction is not reflecting the reality. It's not an automatic injunction, right?
And the
And also,
jurisdiction like China is better in that part?
that's also a big question, not only regarding the damages award, that's one thing, but also when it comes to injunctions, right? Injunctions, and we've seen an injunction, and that was really a huge signal in the Fuzhou court, Apple Qualcomm. That was the first injunction that has been handed down in such a high profile case, right? And so there was a settlement and all that. We know that how that ended in a amicable way. And I think that was also it's also a good example, right? There's an injunction. Of course, that is not the only reason, I guess, why Apple and Qualcomm settled at the time, but it may play a big factor. Of course, it may play a big factor. So with this injunction, they facilitated, I guess, the overall global settlement.
Yeah, no, that makes sense. But I mean, I very much understand that, you know, rich companies like Apple, it makes a lot of sense to go and litigate and spend your millions because you know there will be a lot of money coming out afterwards. They sell, you know, millions of handsets where you get your share. But think about it a bit in the future. We have the IoT market with a lot of different players, right? I would say, in particular, a long tail market of smaller companies that produce, I don't know, a smart meter, or I keep talking about that Berlin startup that creates a smartwatch that, however, is only having a few millions of euros of revenue. It doesn't make sense to litigate those small fishes, right? Any idea how that licensing game will change when you license your 5G IPCom patents to the IoT market?
Um, Actually, I don't know. I don't know. This is a new development, of course, coming up together with the capacity of 5G, having this small kind of machine-to-machine devices, very minimal devices, smart meters, that are worth in production €2, 50 cents, and you have billions of them implemented everywhere, right? Everywhere. And taking a fraction as a fair license will not amount to any substantial revenue, right? So really marginal revenue. We made some calculations based on the addressable markets, markets and devices, and made some calculations, and it's really a low amount. And so we need to see how that develops, and I want to also learn from other licensing companies how they will license the IoT field, how to handle that. At this stage, I cannot say. There is no real strategy behind that regarding IoT licensing. That's something we need to see how the market develops, to be
Interesting.
honest.
Yeah, I think a lot of challenges ahead. Maybe
Yeah.
just a final question. What's up and coming from IPCom? I learned now you are a active standards developer. You're building your portfolio further. Is your focus telecommunication or any other things you can share for the future of IPCom?
So IPCom's mission is to level the playing field, right? To reward investments in research and development, to stimulate further innovation, right? Without innovation, there will be no further convenience for the consumer regarding any field of electronics or any field of pharma, medicine, whatever. We are, of course, traditionally focused on wireless communication, and this is also our strengths. We know the industry, we know the licensing landscape. We had some high-profile litigation cases resulting in unprecedented decisions shaping the SEP landscape. So we feel really comfortable, and we see us, being in that industry in the further generations with this mission, to also show the industry that every invention will be rewarded, regardless how big the company the implementers are. And we do not further want to allow any free riding on inventions, on valuable inventions. And also we want not to allow any further patent dodging. And that's our mission for the future.
Very good. Anything else, Pio, you want the listeners of this podcast to keep remembering about you, yourself, IPCom in general? Any final statement?
Intellectual property law, intellectual patent law. Sorry, once again. Patent law is property law. And we need to go back to square one, to the basics, right? And it's very same as in your everyday life. If you have a nice car, if you own a nice house, as an owner, you want to decide who to lend the car, who's driving your car, who is living in your house, and how much money you want to ask for it, right? And just because you're driving a Lambo and everybody in the neighborhood says, oh, this is a real nice car, I want to also drive that car, give it to me. You still want to decide. Same as for patents. And that's why we need these tools that the legal framework is giving us. And we also need the jurisdictions, the judges, the courts living up to that, really executing these measures in order to level the playing field and in order to facilitate us as a licensing company a fair reward of inventions and a fair reward of property.
Great. Thank you so much, Pio. This was Pio Suh, the Managing Director of IPCom. It was great having you. Thanks for the conversation, and I hope to see you soon.
Tim, thank you very much for the invitation, and yeah, hope to see you soon.